Welcome to the Ron Greenwald Show. We bring you stories, insights, and expertise from leading professionals on the life-changing journey that is estate planning. This podcast is for everyone. We will guide you through our team approach to the AGE, the Aging Safari, and crafting the legacy you wish to leave to your children and grandchildren. We will empower you with the choices to enhance your life now and ensure that your family is able to come together for generations to come. Together, we will make a positive difference. Let's get started. Welcome back to the Ron Greenwald Show for episode 2 with the Honorable Judge David Belz and Matthew Owens, partner with Shepard Mullen. Judge, we're going to turn it to you at the beginning of this episode to talk a little bit more about where we left off on episode 1 and expand on that.
Okay, well, I think it's important to talk a little bit about duties and responsibilities and what the probate code and the public policy is as it relates to these responsibilities. And I'm talking primarily about the responsibility of the trustee in a trust. That's the one that's supposed to be managing it. The duties are pretty severe, and anybody can read them and understand them simply because they're not complicated. In the 16,000 series of the probate code, that is 16,000 through 1653. And just to give you an example, a couple of them, 16,000 of the probate code, and this is under trust administration, the duty to administer the trust according to the trust document. One of the first things that I was taught when I came into probate was you better read the trust. Mm-hmm. Read the trust and then read the trust and then read the trust, okay? Because the trust is the roadmap for just about everything as it relates to what the trustee is supposed to do and what the court's supposed to understand. The public policy is also very clear that it's, and I've done this so many times in court where I looked to the parties fighting over this and I said, you realize it's your mom's money? It's not yours. It's their money, okay? They had the right to say what they wanted to do with it. We have to try to follow what their intentions were. That's really important because sometimes people get, for whatever reasons, into a different mentality, which is not appropriate, okay? It's mom and dad's money, and maybe they didn't make it perfectly clear. We got to figure out how we can do that, but we look to what their intent was. And so that's a public policy consideration. There's a duty to loyalty. There's a duty to be impartial, 16003. There's a duty to avoid conflict of interest, 16004. There's a duty to take control and preserve the trust assets, 16006. So what's my point? And I looked at people all the time from the bench and said, why would you want to do that? You're putting yourself in a position where you could be a target. And you have to also understand as the trustee, you come in last. The beneficiaries are the ones that you're primarily serving. You're serving the intention of your mother or your father or whoever set up the trust, but you're supposed to be taking care of these assets for the beneficiaries, okay? So we talk a lot about intent of the settlor, and that will govern, it should govern how the court is looking at the circumstances. We talked a little bit about joint tenancy, and Matt had a case he wanted to bring up.
So thanks, Judge. So it's always good to think about what your trustees' fiduciary duties are, but sometimes it can be a little complicated to figure out exactly the right steps to take to satisfy your fiduciary duties under the probate code and under the trust document. Sometimes you might have conflicting instructions in the trust on the one hand and maybe a pay-on-death beneficiary designation on the other hand. So an interesting, or joint tenancy account that says an asset's supposed to go to somebody, but that's inconsistent with what the trust says. So one of the interesting cases on this issue is actually one that you decided, Judge Belz, which was one out of Orange County. I think it was the Placencia case. And so that was a situation where you got to decide, is the will going to govern disposition of this bank account? I can't remember if it was multiple accounts or if it was one account.
It was an account that had a lot of money in $100,000. It was
okay.
Yeah.
So is the will going to govern disposition of that? Because there was language in the will about where the asset was supposed to go, or should it just pass as a joint tenancy account to the surviving owner of the account? And so if you are the fiduciary in that situation, so that's an executor under a will, a little bit different than a trustee, but still trying to satisfy your fiduciary duties and figuring out what's supposed to happen with this account, it might not be crystal clear what you're supposed to do. So can you tell us a little bit about how you decided that one?
Well, it was a case where the dad in this case had a couple of daughters, and for various reasons, which we don't need to get into, he put him and his daughter, one of his daughters, on a bank account. I guess she was kind of the accountant type, the one that he would look at and see, she'll handle the numbers, and as joint tenants. We don't know all of the details, but I know that it became a matter that went to trial because when he died, the joint tenancy went directly, that $100,000 went directly to her. And then she took the position that it was her inheritance, right? Because it didn't pass through a will, it just passed by operation of law under the joint tenancy statutes. And that became a contention, and we went to trial. And there's a code section that talks about joint tenancies. And I read this code section. It was pretty clear. It said basically you can't contest the way it's set up. If it's set up this way, that's the way it is. It's written in stone, okay? But I heard testimony that suggested that he did that for a convenience reason. And it was strong enough testimony. It was from independent people. That's one of the things you have to learn how to do as a judge. You have to judge character and credibility. That's really important. And that's why I tell people, if you think you know what's going to happen in this trial, you better think twice, because I don't know what you think's going to happen in that trial, but it may not happen the way you think. And I have to sit there and judge it based on the facts that are before me. And so I heard the case and I heard the witnesses, and I'm looking at these witnesses. I'm going, that's really credible. Those people are credible to me. What were they saying? They were saying that he never intended for it to go to her. He did that for convenience purpose. So now I'm looking at this code section. I'm going, this code section says it's written in stone. It's over. But then I looked at the legislative intent, which, again, you got to look at what the public policy is behind that statute. And I saw, well, this is just to protect the bank institutions for good reason, so that they're not brought in and sued, right? Mm-hmm. Made sense. And so I took a shot and I said, I'm not following the code because I don't think the code should apply.
Did that send up red flags around the state?
Everybody loved it because I got affirmed on appeal, went up on appeal, and it was affirmed because it was the right decision under the circumstances.
Well, and litigators like me love it because even though Probate Code Section 5302 says, hey, it passes to the surviving joint owner, you're done. Now we have, under that case, confirmation of some other language in the statute elsewhere that says, well, there's a clear and convincing evidence exception. And litigators love exceptions, especially fact-intensive exceptions like clear and convincing evidence. Okay, now if I can satisfy and prove to Judge Belz or another probate judge that notwithstanding the fact that there was a joint owner, I've got a will or I've got a trust or I've got some other writing that's going to show by clear and convincing evidence that the decedent intended for the account to go somewhere else. Now I got a contested issue of fact, probably not susceptible to a demur, which is like an early motion to dismiss a case. Probably not something you're going to win on a motion for summary judgment. You're probably going to trial on that. And I had a trial on that very issue not too long ago. So that stuff comes up.
But it's very, very common where, one spouse has passed away. Its mom is a surviving spouse. She wants to put one of her children on a joint account. I mean, that happens all the time just because they want convenience of cash flow. When mom passes away, they want the daughter to pay the funeral expenses, and that's very common. So now that is really not recommended, or
No, it's fine, but I think in your trust document you'd want to make as clear as you can whether that account is supposed to pass under the trust terms, and you could deal specifically with the account, or whether you're going to leave that as an asset that's going to pass as joint tenancy. So a lot of people, for example, will have what's called a general assignment, and what that document does is it says, look, I'm creating a trust, but I also want to have a separate document, my general assignment, that says if I missed an asset and I forgot to fund it into my trust, my general assignment's going to say I want to take all my assets under the sun and put them in the trust. And then that's evidence after you pass away that even if you didn't title the bank account or title, whatever asset into the trust, that actually you intended it for it to be in the trust and pass pursuant to the trust terms. So you can kind of pick up an asset through a general assignment that way. But probably the best, in my view, the best planning technique is if you're going to use a general assignment that says all my assets go to the trust, you got to pause for a second and say, do I really want to capture assets that have a pay on death beneficiary? Do I really want to capture assets that have a joint owner? Because you might want to carve those out, and a lot of people do, so that everything's going into your trust except for maybe assets that have a specifically designated beneficiary.
This is why you do not go to an online
That's right.
trust mill.
Well, I think that's one of the important takeaways, and I think that takes us transitions us into that next topic that I think is really important, maybe the most important thing, and that is and I'll share this story with you. I have a high school friend. My brother actually was his accountant. He has a very successful business with real estate apartments. Okay. In Orange County, and he's done very well with it. He's got quite an estate. And so one day I was talking to him about, because I talked to my friends. I said, do you guys have everything squared away? Because I would see the chaos in court, and I go, nobody wants that. And I said, have you guys talked about this and how are you going to handle this? Now, his son's kind of taken over the business, is going to take over, and that could be a red flag. He's got a daughter also who's not, okay? And he said, oh yeah, I talked to this attorney down in San Clemente, and he told me to get this book, okay? Preparing Heirs, okay? And so I said, what is it? And he says, oh, it's a whole plan on how you need to prepare for your estate passage. And this book is, a lot of it, they talk about large estates. Most of us don't have large estates, okay? But a couple little facts that came out of this, 70%, there's a 70% failure rate in estate transitions. A 70% failure rate. In other words, it never really happened exactly the way it was supposed to.
That's why I'm pretty busy, Ron.
Right?
Why, thank you, Matt, for coming today, because I know time is precious.
Right?
Yeah.
And then, and it talks about 60% of the failures are a breakdown of communication and trust. Really important word, communication and trust between the family members or the beneficiaries. That's a key ingredient. You have kids that don't necessarily trust one another, watch out. That ugly head will raise itself if that trust isn't really clear. And so they emphasize very elements of things that you need to do ahead of time to prepare this transition in wealth of whatever it is, whether it's 100,000, whether it's 5 million or whatever, you have a process that you should follow.
And that I just want to add,
by the way,
to me is, go ahead, Judge.
I'm sorry. The name of the book is Preparing Heirs, and it's a 2003 book, and I'm sure there's others out there, but it's called Preparing Heirs by Roy Williams and Vic Pricer.
And I just want to clarify or add that it's not just for the high net worth individuals.
Thank you.
I mean, if you're in California and you own a house, right, you need to have a plan, because if you have children, like you said, you can divide up a bank account into 3 ways, but you can't divide a house. You can't come in with a hacksaw and divide the house into 3 ways and give a third, a third, a third. And that's where so much conflict arises.
Got a partition complaint that is about to be filed, if not this week, then next week, in a case where it's 3 siblings that are fighting over what to do with the house, and there's no guidance in a trust that says what happens to it. And so now that the parents are dead and they can't agree on what to do, we're filing a partition complaint.
I have a really good example. My best friend.
What is a partition complaint?
It's a way to effectively, it can divide up the interest in the property, but that's not a practical thing that judges like to do. So what you do is you force the sale of the property through basically like a receivership type of process, which is not ideal, because then those 3 siblings kind of lose control over the sale. The house is going to get sold, but it's in a very clunky way that goes through a court system.
Thank you. That's a really good question. What is a partition action? Yeah, that's what it is. Sometimes that's what you have to do to separate everybody from one another, because if they're tied in a tendency of common, where then this question is who owns what, how much, what's the percentage?
So again, when you're the trustee, your parents have named you as successor trustee, you're also possibly, most likely, a beneficiary. Is that an inherent conflict of interest?
It certainly can be. Again, using those 16,000 code sections, probate code sections that talk about if you're in both roles, you even have a higher duty, because again, you come in last. Okay, you're supposed to take care of be a fiduciary, meaning you have a responsibility to others. Here's what I like about this stuff. I love it when I see principles of law that are rooted in our Judeo-Christian concept of what's fair and just. It's basic concepts. And so the code is written around those concepts. You have to be fair and trust. Obviously, honesty is part of that, but they work. And so if you're going to be the trustee, you have to understand that you're there to serve others, not yourself. And he sees it. I saw it all the time where all of a sudden the trustee's doing something. Maybe they made a distribution for two of their siblings, but not the one they didn't like. You're out of here. And by the way, as a judge, this is one of the things I loved about probate. If I saw something that I thought was in violation of the trust, from the bench, without a hearing, without any evidence, I could say, you're suspended. So the code gives us the ability to make sure, because, and this is another really important concept to get out of this. In probate court, a probate judge is a fiduciary. When we teach this, we talk to judges about being a super fiduciary. You're the ultimate fiduciary. You're the one that has to be overseeing, protecting this trust. Remember, we went back to the statute of marmaids and that English? This is where that all comes from. There's this pocket of assets, and there's a user, but there's also somebody that owned it, and their interests and their intentions have to be followed.
So, go ahead.
Build on that. Of course. So, on this suspension concept, meaning the trustee that's named and is currently serving gets kicked out of that role as trustee.
Which we see a lot.
That happens a lot when there's these conflict issues or whatever. And I, as a litigator, use that. There's clear law that allows probate judges to do that. 17206, Schwartz versus LeBeau case, all sorts of good law.
Ooh, that's a favorite court case. That's one of my favorite cases.
I'd be happy to talk about it.
Ron's like, can you guys stay out of the weeds, please?
No.
But so those
I'm
are
going to Google it.
So those are tools that litigators and probate judges have to get a trustee kicked out, and I use that stuff all the time. I had a hearing on that 2 weeks ago where I got a trustee suspended. But just real quick, the point I wanted to make is, if you're a listener out there thinking about setting up your estate plan, think about what happens if you name one of the three kids or whatever because you think they're going to be trustee, and then there's this conflict, and then they get suspended as trustee. It's probably not what you wanted. Now, I think, and Judge Belz, I would assume, would agree with me that in those situations where you need a suspension order, the obvious solution is get a professional fiduciary in there to take over in most cases. And that can sort of rectify the situation, right the ship, get the trust administration moving forward. But if you're thinking about, I'm a client who's about to set up my estate plan, you're not thinking 5, 10, 15, 20 years from now, is some stranger going to end up being appointed as trustee of my trust because I picked one of my kids instead. You might want to give some thought about naming a professional person that you know at the outset, so at least you can interview them, get comfortable with them. You don't want to set your kids up for failure when they try to administer the trust.
We'll talk a bit about the responsibility of being named the trustee.
Yes. Yeah. And because of I was a personal injury attorney for 27 years. And in doing that law, I'm constantly looking at liability, negligence. I became a consequential person. I'm always kind of thinking in terms of, if I do this, what's the consequence? That's a trait that you want in an estate planning lawyer. If we do this, what's the potential for that? You have to think ahead. And so many times I would hear these stories, and nobody's really thinking about, well, if we do it this way, what's the consequence, or could the consequence be? And one of those red flags would be, we talked about this when we were actually talking about putting this podcast on, is, do I want my kids to be my trustee? Do I want to appoint them, and do I want them to be co-trustees? That happens so often because parents don't really think, and I have to say this, I suspect that maybe the estate planners don't really talk to them about the potential problems if you do it that way. It is not a simple decision. It can be, and it doesn't necessarily have to be a problem, but it can be a problem. And again, it used to break my heart when I would see these families just get torn up over mom and dad's money.
I have a judge question. So this is a case that I do the real estate, right? So I came into this case where the the son actually gave up like the last 10 years of his. So here you talk fair and just. And so those words resonate with me, fair and just.
I already know what you're going to tell me.
The son, which is usually the opposite, the son gave up the last 10 years of his life to be a caregiver for his mom. And mom writes daughter out completely.
Yep.
After she passes, daughter hires law firm to contest. So two things. One is people always come to me and say, Ron, I have a trust. It's done. I can't be, it can't be contested. It's in my trust. And that's always, I go, oh boy, red flag. But in this situation, the daughter contested what had happened, what mom had done under whatever guise she did, and then was able to get a third.
Yep.
I mean, so fair and just. What's fair and just? How would you read that?
So I can just say this, okay? That's a very. I was at an event on Sunday, and some lady came up to me and asked me about that very situation. And when I hear those situations, the caregiving situation and the codes that apply to that, which are very strict, okay, I think about how much fun it would be to put that case on and deliver the closing argument, right, Matt?
That's right.
One of the most fun things about being a lawyer is that closing argument.
That's the fun part.
Because if you got a really good case, you can really have fun with that closing argument. So that kind of a situation is more common than you might think, very common, okay? Because as mom and dad get older and they become feeble, they're dependent, okay? They're vulnerable. And so now you get into the code sections that talk about elder abuse. Now you get into code sections that talk about caregivers and presumptions that they unduly influence mom and dad. And by the way, if this is not one of those classic situations where the caregiver can develop the attitude that they're entitled, complicated, dangerous.
Is that what you're? I mean, what do you?
Oh yeah, 100%. And that comes up for me in the context of some kid, quote unquote, retired from their profession to take care of mom, and now they want to get some sort of fiduciary fee, whether they're an agent under a power of attorney, agent under a healthcare directive, maybe they're even the trustee while mom is still alive, but they want to get paid a fee based on what their supposed wages were when they were still working in their other job. You know, maybe they're a physician, let's say I've hypothetically had in a case who quote unquote retired from a physician role and then said, well, I want to get paid as though I was still a practicing physician just for doing the fiduciary services I did for mom. Ain't happening. Well, I don't know. Maybe we should ask Judge Belz. Is that fee petition getting approved?
It's going to be.
I used to be a doctor, so I want my trustee fee to be, whatever it is.
Yeah, and by the way, now you're starting to get into the depth of the complexity of what these cases can turn into. They can be unbelievably complex, where you're trying to sift through what exactly was going on here when mom and dad are gone. And so, and he's exactly right. There's case law on this. We have to judge these cases as judges based on the circumstances and try to figure out what happened or what didn't happen. And often, and this is another thing, and I found this out. I found this out right away when I went into probate and I'm doing these trials. I would deliver these statements of decision and they would be appealed, right? And it's I mean, so often I'm talking to the judges and I'm going, are all of these cases appealed? Many, okay? And I win because I get affirmed, right? And the lawyers win because they make more money, but in the end, is it really ultimately, what's the end result of all of this? Tons of litigation, and that's what we're trying to help people avoid.
So, Judge, you are not on the bench currently. So please tell the audience what your current role is, because I think it's fascinating.
Well, I was a trial lawyer. I had a great career as a trial lawyer. Really, really blessed with it. But in 2000, my ex-partner and I, who works with me now at the same firm, we decided to take the Pepperdine Strauss Institute course on mediation because it was just starting to come on, this idea of mediation results, okay? And it was kind of controversial back then, but I'm thinking, you know what, I like this, right? And so he and I took this 5-day course, right? And what we learned was that conflicts can be resolved. They don't have to continue on. They can be resolved. So this whole discipline of mediation is really evolved. I was doing mediations in my practice for about 8 years before I got appointed. So I've had experience. My ex-partner, about a year after I left, after my appointment, he joined Judicate West, which is where I work, and he's a really, really good mediator. And it was one of the best things I ever did because honestly, after I did that course, I became a better trial lawyer. I had some of my best verdicts. Why? Because they taught me how to look at both sides. So I could anticipate what the other side was going to be arguing, right? And put my case on in anticipation. So you have to have the skill set of being able to push past your implicit bias, which we all have, and be objective. And that's something I've never had a problem with. I could mediate a case and then try it. It's a gift I was given. And I think it's probably because of my background. I was just as this Catholic background where we were taught about the importance of fairness and justice and honesty and principles, right? And if you buy into that, those principles overcome anything else. And so I'm now in this new arena where I'm trying to resolve cases and help people through these situations because
So Judicate West.
Judicate, Judicat, JudicateWest.com. Yeah, they're one of there's companies out there, for those that you don't understand, that do alternative dispute resolution. So lawyers and judges retire and they'll take their skill set and they'll make themselves available to act as a mediator to try to help people resolve cases. So, and there's a number of really good firms in California. Judicate is one of them. So that's my new chapter.
And just think about the immense value that Judge Belz brings to that role, because now we've heard Judge Belz talk on 2 episodes of your podcast about his experience as a probate judge, as a trial judge, and then he's warned us about how long an appeal takes. These are all things that he can speak with authority on at a mediation to convince parties, hey, that final teddy bear that maybe we're fighting over, or that final chunk of money that we're fighting over, do you really want to do that? And so Judge Belz can now speak with authority on those topics, given his experience, and really bring a lot of value to the mediation process.
So Matt, in your years of doing what you're doing, do you see improvement, a change, more drama? As the world turns and we're such an evenly divided, not to get into politics, such this 50-50 country, is that causing more issues in terms of the estate? I mean, I don't know, is there a parallel universe?
I can't say it's causing more. I've been doing this 13 years, and I've been busy since day one in trust and estate litigation, and I'm still busy today. People just seem to want to fight over inheritance, and I
have a little bit of a bias. I think that, unfortunately, when families don't have that really tight connect, okay, and that, by the way, is not to be, it's not a given, okay? It's more common than not. But if they don't have that really common connect as family, it's easier for them to slip into old feelings, old emotions, old whatever, and then conflict arises. So that's one of the takeaways is you have to kind of look at your kids and say, is this going to work out okay? Because if you have a concern for that, you may want to think about having somebody else act in that capacity as a trustee. But I mean, one of the most important takeaways from this book and other books like it are communicate, plan. It is a process of planning wealth transition. It's a process. So signing the trust is not the end of the process.
Yeah, and I'll say, as to my comment too about whether there's an uptick or not, it's not just the people out there that find themselves as beneficiaries that are they litigious, are they not? Sometimes they're put in bad situations where a trust is not drafted well. And then what are you going to do? You're just going to absorb some ambiguity that severely impacts your financial interest in the trust? Probably not. You're probably going to go to court and want to advocate for whatever your position is in terms of what you think should happen with the trust. So, these things just happen to people too, and I don't think we're going to be able to fix all trusts out there as people continue going to trust mills and LegalZoom and all that stuff.
Well, I highly encourage everybody, if the trust has been on your shelf and collected dust for the last 3 or 4 or 5 years, get it off the shelf and re-examine your intent, your wishes, your dreams, because it's got to be done right. Otherwise, there is inherent conflict. And your children. So the goal of this podcast is to help ensure that families will stay together for generations or be together for generations to come. And when I'm in front of people, I always say, do you want to have your children celebrate Thanksgiving together in the future? And they go, well, of course. Well, I go, well, what this document, and I'm not the attorney, obviously, this document probably doesn't solve that problem or resolve that problem. Right. So, Judge Belz, thank you so much for being here
You're
today.
welcome. My pleasure.
Congratulations on all of your successes. Judge Belz is the one who worked at Disneyland as a youth.
Grew up in Anaheim. How far away was Disneyland? So yeah, it was all through college. Yeah, for sure.
So if you want to get to know him better, judiatewest.com. If you're a professional, reach out to him. If you just want to have information on what they do, the more you absorb on this issue, the more you're open about this issue with yourself, the better you're going to do for your family. And that's my big push. Matthew Owens, you're always a joy to be with. We always look forward to seeing you.
Thanks,
and
Ron.
Congratulations on all your success. Judge, you're in the Hall of Fame. Matt, you will be appointed into the Hall of Fame in this arena.
We'll see about that.
No. That's I've already cast my vote. Thank you both for being here today. Make it a great day. Thank you for tuning in to the Ron Greenwald Podcast. Thank you for tuning in to the Ron Greenwald Show. We really appreciate your participation. This topic is very important, so I encourage you to please subscribe and share on all the socials, and have a great day.